first on the list are individuals who have filed Chapter 7 in the last 180 days and had their petitions dismissed for willful refusal to comply with an order of the court. The second is when the debtor voluntarily dismissed her petition or had their petition dismissed after a creditor sought permission from the court to go after the debtor's assets that were secured by a lien. An example of that would be if you had a note on your car, meaning you still had payments due, and in the contract you signed when you purchased your vehicle, you indicated that in the event you did not make your payments on time, the holder of the note was permitted to repossess the vehicle. And then you turned around and went into bankruptcy court with that debt still unsatisfied. The creditor then asked the judge to set aside your request to dispose of that particular debt. And then you noticed that that was happening and you asked the court to dismiss your petition, which of course is your right. You are not going to be able to refile a bankruptcy under Chapter 7. So in other words, the code presumes that you are abusing the process by trying to avoid paying your secured creditors. So how does Chapter 7 work? Chapter 7 begins with the filing of a petition, and the petition has to be filed in a state where you have resided for at least 6 months prior to filing. So if you recently moved, you're not going to be able to file in the district where you recently moved. You have to have lived in that district for at least 6 months before you file. That's a rule for individuals. Businesses, on the other hand, can file where they're organized, and as many people know, you can organize your business in one state and operate in another. Many businesses are Nevada corporations and they operate in California, or they may operate throughout the United States. So a business can file where they're organized, they can file in the principal place of business, and they can also file where a lot of their assets are physically located. In addition to your petition, you have to file your schedules, which include your assets and liabilities, schedules that reflect your current income and expenditures, the statement of financial affairs, which is the most extensive document that you need to complete as part of the Chapter 7 packet. And in that particular form, which is probably 15 to 20 pages long, if properly completed, you will detail all of your financial affairs for over the last 2 years or more, including how much you paid your lawyer if you chose to hire one to assist you with your Chapter 7. You also have to list all of the executory contracts that you have that are in effect at the time that you file your Chapter 7. Executory contracts are things like leases or other contracts that affect your property or your assets that have not been completed at the time you file your petition. And the most common example of that would be a lease, an unexpired lease. Now, interestingly, another aspect of Chapter 7 that would preclude the completion of the means test would be if most of your debts were not primarily consumer debts. And consumer debts are debts that you incur for personal or household or family purposes. For example, if you went and borrowed money from a furniture store, or you financed furnishings that you bought from a furniture store, those are classically considered consumer debts. However, if you owned a small business and you were filing Chapter 7, both on account of your small business debts and your individual debts, if the majority of your debts arose from your business, even though you might have a substantial amount of consumer debts, you would file that as a non-consumer Chapter 7, because that Chapter 7 would then be characterized as one that was not composed of primarily consumer debts.